Hi, I'm Bill Daniels. I'm a trial lawyer in Southern California, and I'm one of the founders of Loyola Law School's Institute for Advanced Trial Advocacy. Today we're going to talk about requests for production, which are a type of written discovery used by lawyers to gather documents as evidence in a lawsuit. Requests for production are a common discovery tool, discovery being the evidence gathering part of preparing a case to present to a judge or jury. Requests for production can come by themselves, or they can be attached to a notice of deposition. In either case, the rules for responding are pretty much the same. When your lawyers send you a copy of the other side's production request, read through it carefully. Some of the items may be simple to find, some may not. Make up your own list of what you have, what you don't, and what you're confused about. Then call your attorneys and discuss how you should go about starting the gathering and organizing process. While you go about it, try to keep in mind these 7 tips for gathering documents in a lawsuit.
Tip number 1. It's okay to be human.
The big rule you need to keep in mind is you don't need to engage in a superhuman effort to track down each and every document the other side is asking for. In litigation, we generally only need to act reasonably in responding to discovery requests. So, if you have reasonable access to a document and it's requested by the other side, then turn it over to your attorneys. If you don't have a document but know where to find it, give your attorneys that information. If you don't believe any documents exist that might respond to a particular request, be clear identifying which requests you can't produce documents for. Finally, help out your attorneys by doing some simple organizing before you turn over documents in your case. The kind of organization you should do depends on the kind of case you have. So, for example, if you have a personal injury case, then separate stacks of documents having to do with the accident, your medical treatment, your medical bills, and any other damages you are claiming. This will make it much easier for your attorneys to focus on getting you a great result.
Tip number 2. Gathering your documents.
In California, the documents you will need to produce are those in your possession, custody, or control. Since California bases its own discovery rules on the Federal Rules of Civil Procedure, the possession, custody, or control standard is a good starting point for anyone, though rules may vary from state to state. Possession, custody, or control means documents that you have in your immediate possession and those you can get to reasonably easily. Stuff you have in boxes or file cabinets at your home or your business are simple. You need to go through them in a diligent manner and find the documents responsive to your request. It gets a bit more complicated when the documents are somewhere else. Generally, our practice is, if we know responsive documents exist, but they are somewhere that's not easy to get to, say a doctor's office or an accountant's file, then we tell the other side where they are and either let them gather records on their own or act as a go-between, whatever works the best. Don't stress out thinking you need to drive all over town or up and down your state gathering documents from remote locations. Discovery is about gathering information. It isn't meant to punish you. So relax, do a good job gathering what you can, but don't drive yourself crazy.
Tip number 3. Privileged documents.
Sometimes the request for production will ask for a document that is private or has some kind of privilege attached, like a letter from your attorney or a note from your spouse. When this happens, it's important to provide the document to your attorneys and make sure they understand what it is so they can raise the appropriate objections. This is especially important where there are attorney-client communications that are being asked for or when tax information is requested. If you don't identify the privileged documents at the proper time, there is a danger they will lose their privilege and you will be forced to produce them. So again, be diligent in gathering responsive documents and do try to organize them somewhat before turning them over to your attorneys.
Tip number 4. Don't worry if a document doesn't exist, but be sure of yourself.
When the other side asks for a document that you are certain doesn't exist, don't worry. Just let your attorneys know, and they will draft a proper response to the request. On the other hand, be especially careful here. If you say a document doesn't exist, and it turns out later you were wrong, it can hurt your case. Generally, if a document is good for your case, and you have it, but don't produce it at the right time, you risk the judge ruling that you can't use it, which is a bad thing. So if you don't have it, say so. If it doesn't exist, that's okay. But be sure of your facts, and if you're uncertain, make sure your attorneys know.
Tip number 5. Organizing documents.
When there are a lot of documents you need to produce, it's okay to turn them over in the manner that you keep them during your regular course of business. In my office, we usually scan and number documents before they're produced anyway, so if we need to specifically identify certain categories or types of documents included in a course of business production, we can refer to them by identification number and no worries. If you're able, though, it is usually helpful to your case if you do some organization before you turn over documents to your lawyer's office. Your attorneys want to get right to the heart of your claim, and if they have to wade through a big clump of unorganized documents first, that takes away from the time they can spend on the important stuff. It's not unusual for me to ask my clients to put their documents in chronological order before I go through them. In a complex case like an employment case, insurance bad faith matter, or class action, being able to review everything chronologically allows me to understand much more quickly just how events unfolded over time. The better organized you are, the easier it is for your attorneys to help you win your case. So spend a little time on this.
Tip number 6. Be careful with original documents.
There are some original documents that are hard, if not impossible, to replace. Original deeds, wills, stock certificates, and similar instruments come to mind. If you're asked to produce originals, that's fine, but make sure you help your attorneys keep track of them. Sometimes you'll want to just turn over everything to your attorneys and trust them to keep everything safe. But in the case of irreplaceable originals, you'll probably want to discuss with your lawyers how they will be stored and what kind of access you'll have to them. You may even feel more comfortable holding on to the originals and giving your lawyers copies. Use some common sense here. While attorneys are careful people as a rule, in a busy office, sometimes documents will be misplaced. Protect yourself by hanging on to irreplaceable originals when you think it's appropriate.
Tip number 7. Be timely.
Like everything in discovery, there are time limits on producing documents. Your attorneys will give you the deadline, and you need to respect it. Usually, you can get more time if you need it to respond to a document request. But be careful of your deadlines, or you may lose the opportunity to present evidence important to your case, and you might even be ordered by the court to pay money as sanctions. So be diligent, be organized, take care with the originals, and watch those deadlines. That's all I have on producing documents today. Thank you for your time, and good luck with your case.